Abba. Oh, I should keep it here. Correct, yeah. Thanks. Okay. Hey, look here. I was originally supposed to do this lecture soon after lunch. I decided to postpone it to the second session because I don't think I can make this session extraordinarily interesting or anything like that. Because we are going to talk about procedure, okay? There is not much of scope in improvising the procedure. You understand what I am saying? In fact, if you deviate from it, you will be subjected to questioning, isn't it? There is something called standard operating procedures which are accepted around the world. You have to stick to it, okay? So, in fact, I am the worst person to do the patent office procedure. Because basically I am a litigator. You understand what I am saying, huh? And in a typical law firm hierarchy, each one has got some pigeonholes. It's not exactly my pigeonhole. You understand what I'm saying, huh? Okay, but let me try and do it as less boring as I can, huh? All right. Now, there are a lot of things, you know, like the teachers in IIT, Dr. Indrasan, who is a very distinguished director of the Madras IIT, he said about IIT syllabus this. I'm not talking about our law college's syllabi there actually. He said, 30% of what I am teaching is obsolete. 40% of what I am going to teach will become obsolete by the time the student finishes his 4th year. So I am supposed to teach only 30% things which is current. You know, you understand what I am saying. And the first slide is classic illustration of what has become obsolete. Okay. I will begin the slide with the statement there are 4 patent offices. Delhi, Calcutta, Mumbai and Chennai. Seat of the controller, Mumbai. Okay. Now, usually, if the applicant is having the principal place of business in Chennai, he should make an application in Chennai, not in Calcutta or Mumbai or anything. But we are talking about an organization like TCS. They have a center in Hyderabad, 10,000 people work. One in Bombay, 5,000 people work. One in Bangalore, 12,000 people work. The invention can originate in any one of these places. In fact, there is a possibility a guy in Chennai had collaborated with a guy in Bombay. And the application may be filed in now the patent office follows what is called as the e-filing. And there are discounts given to you if you adopt this route. So it doesn't really matter where your registered office is located, but that's one of the important formalities I like you to check actually. Okay, ease in handling. Now, this is the jurisdiction, and there are serious issues in company law. What is the principal place of business of a company? What is the principal place of business of a company? Huh? R&D. Many companies don't have R&D. Many companies may not even have a manufacturing facility. In pharma, that is the norm. Am I not right? You will have a contract manufacturer, right? You said something? Head office may be different from registered office. Yeah. The devil, they say in English language, is in details. But don't worry. But be very careful. If your company is located Tata Steel, you know where is the registered office? Where is the big plant of Tata Steel? Jamshedpur. Where is the registered office? Jamshedpur. where most of the business of the company is carried out? Tata House, Mumbai. You understand? That is a corporate office. Different from the registered office. Their manufacturing plant, maybe in a fourth state, Rourkela, which is West Bengal, I guess, right? Whatever. I mean, so all these things are procedure, and it is very, very important is that now the patent office is trying to go into e-governance in a very big way. Okay. So they encourage you to do everything online. But unfortunately, the Indian IT infrastructure or the inability of the professionals to get used to this new IP, whatever it is, I have found it to be most user-unfriendly thing here actually. Okay. Maybe that's my problem, and all the more reason why I am not particularly qualified to talk about the procedural aspect of it, but nevertheless, since that's a job given to me, let me do it as cheerfully as I can. That's all about it actually. Okay. You have to upload first online and thereafter send everything by hard copy. That is what is the sum and substance of the first 3 or 4 slides. Okay. Now, two things here. Filing strategy. This is very, very important. When I am talking about a filing strategy, you can file either a complete specification or a provisional specification. So my question to you is, when will you file a provisional? When will you file a complete? This is the first thing, You can either lodge a provisional specification or you can straight away lodge a complete specification. So the first decision that you have to take is whether I am lodging the provisional or I am lodging the complete. What's your answer? Good answer, I got it. I rephrase it differently for the people who have not heard her. There are 2 stages in the invention. Okay. 1, the inventor may come and tell you, hey man, everything about the invention is known to me. Okay. If you are having the regulatory approval in place, and if you give me the money to work the invention, I can do it tomorrow. In that case, you lodge complete specification. When everything about the invention is known, you lodge a complete specification. On the other hand, the inventor tells you, hey, I know it will work here, but there are a lot of loose ends that I need to attend to before it works optimally in an industrial scale. In that case, you file what you call as a provisional specification. This is the first decision we make, either to lodge a provisional or to make a complete. Provisional you do when everything about the invention is not known, and complete specification you do when everything about the invention is known to you. The rule is, the first rule is, if you file a provisional, you have to lodge a complete within 12 months. And if you don't do it, your application will be deemed to be abandoned. But sometimes it may so happen, we are all Indians, right? We don't do most of the things on time, right? It becomes some kind of a culture. It's a problem actually, right? Now, so what we will do? The inventor will say, no, I am going to a conference, so I cannot finalize this. So, you can post-date a provisional specification subject to a maximum of 3 months. Suppose you don't do it in the 12th month. One day before the 12th month, you can go to the patent office and say, give me 3 months time. Post-date my provisional specification. But if you don't do it within this 15 months, that's all. That patent is deemed to be abandoned. And please remember, patent law is a highly time-bound process. Okay? If you don't do things on time, there is no way. You know, we lawyers are very fond of a provision called Section 5 Limitation Act. Have you heard of that? That is, law expects you to do things on time. If you don't do things on time, today you will be seeing that CBI in Bofors case filed an appeal 4,562 days beyond the time provided for appeal. Of course, Supreme Court dismissed it. What I am trying to tell you is, the lawyers use the Section 5 Limitation Act for the purpose of condoning the delay. And that facility is not available in patent law. Patent Act is described as a self-contained legislation. The Patent Act itself tells you the time within which most of the procedure and formalities have to be complied with. If you don't do it, that's the end of your patent application. That is something that you must be very, very careful. Suppose you are a patentee, lady, the inventor. The question is to you. Suppose you had made a patent agent. Suppose you didn't, I know that. Did you meet? Not yet. Okay. What is the stage of your patent application? When was it launched? Was it a provisional or a complete? It is about to, you have to lodge a complete specification now. Suppose you come up with an invention disclosure. You are the inventor for the first time, right? Had you met a patent agent or a professional, there would have been something that you would have asked him, right? What would be your questions here? No, that I'm not asking. If you ask me, I will not give an opinion on that. If you are in the industry, you better know it is novel or not. How can a lawyer like me will say, I may try to give you an impression, yeah, I'll check everything for you. Because I'm going to bill you after all, right? Huh? You understand? Huh? That is how we all work actually. But you know, honestly here, if you are a pharmacologist focusing only on a particular molecule, you have known 1,000 things more about that molecule and the process, activity and all that than me. I mean, I will only, when I speak to you, I will only conceal my ignorance on that actually. You understand? And make you believe I have understood you. Okay? Eh? That's where the skill is actually. Only then you will think that I am somebody of consequence and you will continue to consult me. Isn't it? It's okay. I'm talking to you some of the professional secrets straight away, but nevertheless that's the reality actually. Come on here. You are meeting me. I am your patent agent. Shoot your questions now. What will be your first question? Forget the fact that you are working for a company, which means you are not going to take the decisions. Isn't it? I know that. In an average corporate environment, you know what the inventor gets? $10 rise and sack after 1 year. But 1 year time is for the company to understand your invention. If they understand you, they have no need for you thereafter. Am I not right? You know, I am talking about the stark realities of the dog eats dog corporate life. Okay, that's cool. I mean, dogs are known to be cannibalistic, unlike humans, so it's not a big deal. Suppose you are an individual inventor. You come up with the molecule. And we talk about the NUMS test, we apply novelty, utility, non-obviousness, statutory subject matter. All that is over. We say everything positive, tick, tick, tick. Right. Then what will be your question? Now I want you to understand this process, I told you owning a patent is like owning an elephant. Okay. There are a lot of people who have ruined themselves with patent. I very strongly recommend all of you to read Charles Dickens' Poor Man's Tale of a Patent. Just about 12 pages here. Yeah? I always say that if you have a project, you should chew your project. Your project should not chew you. You understand what I am saying? Yeah? So I always tell people, attempt to do things which is realistically manageable for you. If it is not, I am not going to look into the correctness of your invention because it is beyond my scope. You understand? That's not what I can do. But I can definitely tell you whether it is patentable or not. Okay. Suppose you are the inventor and you have to spend the money, right, of your company. What would you like to know? There is no guarantee for anything in life. That will be my answer. And if I give you a guarantee, I am dishonest. You understand what I am saying? But I can, with a reasonable certainty, I can tell you whether it is patentable or not. That's all. It's an educated guess, but not a guarantee. Okay? Well, let us understand that very, very clearly. Because there is a lot of... Any other questions you will ask your agent? Oppa. Hey, assuming that we have a valid patent. Number one, how long it will take. Do you have anything else? That you will ask for the moon, and if you don't get the moon, you will be happy with the rock in the moon. Isn't it? That's a human nature again. So that's okay. Is there anything else? Oh, that's it. That's what interests me also, actually. Two things we are going to be bothered here. Number one, how long it is going to take. Number two, how much it is going to cost. These will be the realistic questions I expect to answer from an inventor. Every other thing I just listen, that's all. Okay? Now, for your first question, I'll ask three other counter questions. How do you consider yourself? Generally lucky, generally unlucky, lucky sometimes, unlucky most of the times, unlucky sometimes, lucky sometimes. Isn't it? That's what everybody's life is here. Then I will say, if you are lucky, and if you make an application in United States, okay, you may get it between 1.5 to 2 years. If you are moderately lucky and apply it in Europe, you will get it between 3 to 4 years. If you are terribly unlucky and if you make it in India and you get one patent in 6 years, consider yourself extraordinarily lucky. Do you understand? When I say this, the patent office people get extremely irritated. Some of them are my good friends. You'll be seeing them also. You can ask about the time frame to them also. And you can tell this answer also. Then they will say, oh, Murli said this. Okay. So, it's not unusual for a patent to get sealed in 2 years here. But in some states, earlier in United States, the period of protection was from the date of grant. So many of the companies had a vested interest in keeping the application pending by the time they get the regulatory approval and then launch the product. Now, it's all very clear. 20 years from the date of priority. That's all. Okay. So, there is always something called the patent term extension, we are not really following that. Matthew, I'm in a class. I'll call you in 1 hour's time. Okay? Thanks. Okay, so that's how it is. Now people will ask, why should it take 5 years? This is another question. For that you have to understand the patenting process. Number one, you file an application, and all applications and complete specifications are published within 12 months. That is the stage one. Now, within 18 months of publication, within, there is a time, not too sure about it. As I told you, I don't normally handle these things. Only when those people don't do on time, they come to me and say, sir, we have messed it up, please do something about it. And very often I'll go to the office and, talk to them and try to save it. And in a few cases, even we couldn't save, and they say, thank you, bye, that's all over. Okay. Now, within 12 months of within 18 months of the application, you should lodge what is called as a request for examination. That takes place within 18 months of first filing. Keep it like that. I may be wrong here and there, but that's, I can just say you the general overall process actually. And sometimes you could do it in the case of PCT application, you should do it within 30 months of the first filing. Okay, a lot of other things depending on what the applications are, you do that. Request for examination and examination. And this examination, actually I must tell you, Albert Einstein began as an examiner in patent office. You must have heard about him. And they asked him, what one single event that made you a scientist of this much fame? His reply was, my experience as an examiner in the patent office. Because that's where you get all the inventors disclosing what is state of art. Sometimes I always find, as a lawyer, I don't meet smugglers, black marketeers, tax evaders, child rapists and all. I meet inventors. You understand? It's a nice feeling actually. And somebody whom I can introduce to other members of the family, which I may not do if he is a child rapist, right? Okay. So you actually get to work with some of the best brains. It's a very nice feeling actually. And your learning continuously improves all through. Maybe just bits and pieces of it, but nevertheless knowledge is always enjoyable. That's how I always believe that. Now, after you get the examination report, you have, see now how much it is? Provisional, complete 1 year, publication 12 months, request for examination 18 months, and the examiner takes almost about 1 year to give the first examination report. This becomes 2 years and 9 months. You have 1 year time to comply with the objection, so that becomes 3 years and 9 months. So, if somebody tries to tell you that, hey, I'll get you a patent in 30 days' time, be sure that he's a liar. You understand what I'm saying? Yeah? Very simple, but at the same time, I would say that there is in between, somebody can, under section 25(1) of the Patent Act, there can be what is known as a pre-grant opposition. If there is a pre-grant opposition, the 3 year and 9 month period will become almost 5 years. Okay. But most of the people do not bother this pre-grant, except the group, Medicines Sans Frontiers, Doctors Without Frontiers. Whenever there is an AIDS drug, whenever there is a TB drug, these doctors without frontiers will lodge all this, They want to postpone the inevitability, which is nice, ideologically, okay. Now, and there is also a post-grant opposition and maintenance. Now please remember, who can file a patent application? See, here there is a very big difference. USA Patent Office refers patent applications by the name of the inventor. Many patent offices around the world refer the application by the name of the applicant. Inventor is an individual, the applicant is always a company. Okay, but please remember, the right to apply for a patent is basically the right of the inventor. But the inventor is under a contract of employment. And the contract of employment assigns all the rights to the invention to the employer. So, the applicant is always the employer. But you may be a software specialist. When you go to the office, you start playing golf. And when you play golf, the balls get lost. Either they go into a ditch which is 10 feet deep, or the ball gets stuck in a tree which is 20 feet high. You invent a golf ball retriever. Does the invention belong to the company? You are a foreigner person. In your spare time, you go and play golf. In Bangalore, Hewlett and Packard is located in a golf link actually. And in fact, to encourage people to come to the office during weekend, the company encourages them to play golf. You understand what I am saying? There are golf ball kits and all that you don't have to buy. They are very expensive, obviously. Right? So, the company gives you the facility to play golf. You invent a golf ball retriever. Will it belong to the company? This is a legal question. That's why I am asking you. No. It has got nothing to do with the contract of your employment. Invention that come in the course of the contract of employment. For, you see, I may be working on you for 3D technology. But for somebody, I can work on 2D. See, whatever you understand, there are Elon Musk, that guy who's a weird innovator. He's next to Thomas Alva Edison actually, right? And that guy, one company will assign one type of patent. Paul Allen, that guy, Microsoft guy. Okay? He put in a lot of money on movie business, even though he was working on Microsoft. So long as it is not software driven, okay, if it is a movie, Allen himself can say, look, I am the owner and not the company. And please remember, under the Patent Act, natural persons, which means what? Individuals. Small business entity, which means what? Somebody who employs less than 25 people. Startup, which is a very interesting thing, because the people who is really bothered about the time frame are small inventors and the startup companies. Depending on the patent, they have to find a venture capitalist. And thereafter, they have to find a support for marketing, manufacturing. One is different from the other, right? Okay. So, these are different one, and all these things are, we have to see in which category you come. Because the fee also is lower for natural person, small entity. Startups, if they pay something extra to the government will examine it out of turn. And probably you can get a patent in 1.5 years' time also. If your entire life depends on this patent, okay, then you can make sure that it is done. All right. Haha. Please remember, in our course, we only focus on substantive aspects of patenting. We don't really go so much into the procedure. This patent diploma, if we are successful in getting it, I'm sure there is a market recognition. I'm aware of that because we are doing this course for the last 12 years, and generally market has been very kind to people with a PG diploma from NALSAR. Sure, I'm not disputing it because every year I find people from your organization. Okay. If it is not so, they are not going to come here. As simple as that, actually. But again, what I am trying to tell you here is, for your marketability to substantially improve, and if you want to really make a career in patenting, you must pass the patent agent examination conducted by the Ministry of Industry, Department of Industrial Planning and Public Policy. The last examination was held somewhere last month. Usually they try to hold the exam once a year or at least once in 2 years. Okay. So, your journey as a patent specialist begins with probably NALSAR diploma course. It cannot end there. You know, now you become an academic patent personnel. For you to become a patent professional, you must clear that exam. In that exam, they don't so much bother about your substantive knowledge. There are questions, obviously, you know, paper 1 and paper 2. And paper 1 is intended to focus on the substantive areas. Paper 2 is a patent specification writing. And there is also a Viva verse where they will be questioning you on the various forms involved. Form 1 is the application for patent. Please remember, most of us think that filling a form is the most monotonous job, right? I sometimes go to the bank, sit there with the accountant or whatever, because of my age or whatever it is, they like to do that. Then I see law students coming. They fill up the paying in challan in the bank. Believe me, they miss 3 or 4 essential particulars. You understand what I am saying, eh? So, don't think, and if you make a mistake here, the patent office examiner is bound to point that out. And if he doesn't point it out, his superior will ride him. You understand? Therefore, he would lose no opportunity to reject your form because it has not been filled properly. If that happens, your client will sack you. Very, very simple. No tolerance here, you understand? If your child is sick and if you go to a pediatrician and if a pediatrician overlooks a fundamental issue, will you go to him again? And that applies. And please remember, IPR professionals on an average get sued more for professional negligence than other lawyers. So, actually there is zero tolerance for errors. I want you to understand that actually. Okay, because please, you are working with innovators, scientists, technologists, who are, as I told you, different from some of the categories of people that we normally lawyers have as clients. Okay. So, that's number 1. And the most important part is proof of filing. Paragraph 9. And one thing that the patent office insists on is they don't like abbreviations. Because different applications, abbreviations mean different thing. For example, CAS. What is this abbreviation? Huh? That is what you say. I am an economist. I will say current account surplus, and this lady may be a telecommunications person, and this lady will say conditional access system. You understand what I am saying? What do you think he has the normally accepted abbreviation, okay, is unacceptable in a page. I am only talking about the basic ground rules. And I am a professional. Let me tell you, most of the professional problems that you face in your life, if you know the basics, and if you know them well, you provide them a solution here. There is no need to do research. I can assure you that. Research is a very good quality. But for filling the forms and things like that, be very thorough with the basics. There is no need to do what I call as the complicated research. See, I am used to receiving a lot of interns who are law students. And most of them have patent law as an incentive when they come and join with me, because you know that we don't really pay much for the interns. They come only for the learning opportunity. And they all say, sir, I asked them IP. I'm interested in IPR, right? That's why you joined the course. Which IPR, I asked them. Most of the people say patent, some people say trademark, some people say copyright. You know what I do with them? I give them a specification and ask them to read and come back to me. Next 3 days, they will never come back to me. You understand what I am saying? And you know, reading a patent specification, to me, at least, without hesitation, I will say, it has been the most intellectually demoralizing experience I have ever had in my life. Okay? I consider myself reasonably bright here. I am not a Dumbo, for sure. I know that. All my peers recognize me as one. There is no doubt about it. But there are patent specifications I have read for 3 hours, 4 hours, and at the end of it find, okay, I have understood about 10 or 20%. That when I am generous with myself. You understand what I am saying? Then I sit with the next industrial domain guy, talk to them. This understanding from 10% it becomes to 40%, 50%. 2 more meetings, it gets close. And by the time we get the patent, I am reasonably good at that. That there is no way so what I am trying to tell you is, the patent interns, when they come and read a specification, well, next time I call them, hey, you said that you are interested in patenting, come back. Sir, there is one copyright assignment, I am preparing a contract. Can I finish that and come? Then I will understand. Okay, they are not really going to come back to me. But there are always brave ones who will come back to you. You understand what I am saying? And they will say, I didn't understood a word about it, sir. Then I say, welcome to the club. At least you are being honest. If you know that you don't know it, there are chances that you will learn it. Okay? We must know that we don't know it. That's the first thing in learning, actually. All right. 3. Statement of foreign filing. See, one of the important rules about which I will say is that every patent office wants to keep track as to whether you are going to file patent application in other parts of the world. It may so happen, US may grant you a patent, prescription patent, using acetyl salicylic acid for treating a cardiovascular condition. US it may be a patent, prescription patent. India you wouldn't get it. Just because you got it in US doesn't mean you will be entitled for it in India. Because one important rule about patent that I want you to understand is, patents are strictly territorial. If I were to use a legal jargon there, strictly territorial. It is valid for the territory in which it has been granted. in patent jargon, we use this word called safe harbor principle. India will not give a product patent earlier. Now we have been granting. But process patents are available. Okay, if somebody makes a product by a process different from what you have done, there could still be a patent for it. Suppose it originates in a place where there is no patent protection. Normally, some protection will be available once it goes into a third territory. But if patent is available for it, in India it will not be an infringement, in USA it will be an infringement. You understand? It can happen. Okay? Right. Declaration as to inventor shape. What do you mean by that? In India, a PhD scholar, I always say that nowadays. Many don't like me. In fact, I went once IIC. Somebody gave a research proposal. I am not even a scientist actually. But then the professor said, what do you think about it? The first question I asked the student, hey, before preparing your research proposal, did you do a search on patent database? He said no. Then that professor said immediately, it's your unfortunate thing that this man was here. Now I have to tell you, go do a patent search and come back. You understand what I am trying to say? Like if you are not doing a patent search and if you are going to give me a research proposal, hey, you haven't done 50% of your job here. But many scientists get annoyed with me for this actually. Okay. And I always say, what is in Tamil there is a proverb. Grain has been ground into flour already. Why grind it all over again? You know, most of the researches that we do in our country are only in that category. Am I not right? That is sad. Repetitive, adaptive research. Adaptive research at least I can understand. There will be what you call as incremental innovations to suit the local condition. But to grind the flour all over again and again is very bad. Request early publication, request for examination, form of authorization, and if you are filing an Indian application in pursuant to a foreign application, you have to get a certified copy, abstract, inventions and all that. Actually, I skipped this. The next 3 slides, I am going to skip it. Okay, form 1. Because that is the free form, everything. There is no way you can pass the patent agent exam without that 3 slides actually, which I just now skipped. I used to say jocularly, if I write the patent agent examination today, I'll fail. Things have become so difficult actually. And please remember, in the patent agent examination, the pass rate is not more than 30%. 70% of the people who write, postgraduates, doctorates, lawyers, fail. You understand? So you must be very, very thorough when you take that examination and don't get demoralized if you fail in your first attempt. Many people it happens to them. Next attempt you may definitely do that. Applicant's name, okay. Nationality and address. Inventor's name, nationality and address. This is nationality is a very, very crucial fact. And Patent Office does not want any abbreviation that includes your name. You can't write R. Muralidharan. You have to write Raghavachari Muralidharan. You understand? No abbreviation even in your initials. Okay. So, many of us will just write the name or Muralidharan. For that the form will be returned. Okay. I think we should avoid that. A stitch in time saves 9. Address for correspondence. Title for the invention. Actually, sometimes I see scientists, many times actually, now of late it is much less. I'm not so much of a filer. they will have about 6 or 7 line title. You know, a very highly focused specific area, one branch, blah, blah, blah. I always say, hey, you know what is the purpose of a title? It must be easy to remember. First point. Number 2, it must be easy to pronounce. Number 3, it must be attractive enough. That's all. So my best title for me is not more than 4 to 5 words. Okay? And you know, who will read the patent specification? How many of you have read a patent specification? You have. Okay. How do you like it? Was I not right when I said it is one of the most intellectually demoralizing experience, notwithstanding the fact you read specifications which are of your own domain, isn't it? Not always. Okay. So, I mean, you will agree with me when I say, so most, who will read here? Nobody will read a patent specification. I would happily read a John Grisham thriller, P.G. House, Woodhouse comedy. Why bother reading a patent specification of all here? But who will read? You have to think about that. Normally, first person to read your patent specification seriously will be company. Agent he prepares actually, so you may not really read it again. I'll give it for somebody to scrutiny. Appa. First person who will definitely read your patent application is the examiner. He is a person skilled in the art. So he will understand most of the things that you talk about. The next person who will decide on your patent in the patent office is the controller. Controller is a technical person, scientifically trained person, but he may not be in the same domain on which your invention had originated. So that guy also, if I am going to get a what I call telecommunication patent, I don't know what decision I'll take. Whatever my subordinate says, yeah, it must be right here, let's try that. Are you sure? I'll ask that. If it is Uma or Shanti, are you sure? If you are sure, let me push it here. Because I'm not really, cut out for that, except if it is something blatant, which I can see it straight away actually. Okay. Then, this is priority particulars if it is a convention country. If it is an improvement over an existing patent, that is called as a patent of addition. Okay. Then the basic one, declaration of inventorship. In private limited company, I remember 1 or 2, how many are from Reddy Lab? Okay. Sometimes I find that companies indicate directors as inventors. Would have been a finance man. You understand what I am saying? Then, but it's more out of what I call as a courtesy. PhD scholars will put the guide as a co-inventor. Otherwise, you will not get a permission, right? This is what I call as a misdeclaration of inventorship. But these are all aspects in India we have not really bothered here. And please remember, this misdeclaration of inventorship is an inequitable conduct on the part of the patentee. If the patentee is guilty of an inequitable conduct, the patent becomes unenforceable. So you must be very, very careful. But if you press too hard, you will lose that client. Hey, this lawyer is too complicated. He is interfering in all our internal matters, right? Said that guy. Never mind, but it's cool. But we need to tell them, hey, if you disclose somebody as an I have seen 2 or 3 cases. Somebody in one company invents, he probably disclosed to the company. The company was not interested in the patent, so he is telling his friend who is a neighbor to file the application. This can also happen, right? Well, some of it had worked also. You understand what I am trying to say? In fact, who invented telephone? Wrong answer. Alexander Graham Bell was the first one to patent it. He was not the inventor. That is because USA had a very peculiar law. First to invent got a patent there. Okay. And in fact, Alexander Graham Bell was involved in a very big litigation, and he died under a belief that somebody else is the inventor of the patent. After he died, his son got all the compensation actually. I mean, he is one of the famous misdeclaration of inventor. Okay, now I am telling you here. Please remember that I think I discussed this part already. Okay. This is very, very important. This slide, I think I'll focus slightly longer. This is important because you have paper 2. Writing a patent specification. When we are talking about digestive system, mouth, buccal cavity, pharynx, alimentary canal, stomach, duodenum, small intestine, big intestine, rectal tube, pancreas, liver, right? All are parts of the digestive system. In +1 examination, if whatever figure you put, and if you write these names, tap, they'll give you marks. You understand what I am saying? So whenever you write a specification, follow this format. It begins with what I call as a title. Okay? I told you what the title should be. Okay? It must facilitate a quick search. There must be a realistic connection. 4 or 5 lines. Then, field of invention. And I will come back here. Who will read the specification? First examiner, next controller, third who will read? The inventor will go to what you call as a venture capitalist. Because in pharma industry, cost of generation of the molecule is less than $50 to $100 million. You know what is the cost of getting regulatory approval? Any idea? $400 to $500 million. So even if you have a good pharma invention, for it to become prescribed medicine, somebody must put in $300, $400, $500 million. That guy is going to give him his hard-earned money, right? That guy will read it. This is the next guy who will read it. Otherwise, nobody will read a specification unless they are compelled to read it, like most of us. Right? Afterwards, you still need money. Car like Tesla. What are they working on? Tesla is working on what? Huh? That's all. Driverless car. That is their product which they are offering in a limited scale. They are going to operate in a big scale. And for it to become a reality, firstly, regulatory approval. Secondly, manufacturing. Manufacturing in global scale. So you need lots of money. Then you will come as a lending banker. First is an examiner, second is a controller, third is the venture capitalist, and fourth is a merchant banker who is going to give him the money for the company to provide the working capital. So then the next fellow who will read is what do you call as a initial public offering. What is the assets of the company? 25 patent. That guy will read. What I call as an underwriter. In corporate parlance, they call them as underwriters to the issue. Okay. Then you will read, a judge will read. In this, if you had looked at, only 2 are technical people, all others are non-technical people. So a patent department is a techno-commercial legal document. That is what I want you to understand that. Techno-legal commercial document. You put it this way also. Okay. So, it must be comprehensible. If we are going to see, when we were all children, we were all made to believe, if you write English with words, which compels other people to refer to dictionaries often, you are big here. Actually, that's a bloody wrong attitude. You understand what I am saying? Tell it in a way which people can understand here, which is very, very crucial actually. Okay? People have no time to test their knowledge. I have always hated Justice Krishna Ayer's judgments. When I say it, I become an unacceptable person in law colleges, isn't it? That man is a, what do you call, demigod status in the profession and industry. I used to tell him also, very straight. Sir, what is this, sir? If I have to refer the dictionary every 3rd line, I am not able to focus on what law you are writing. And you are most eulogized because many people don't understand what you write. Huh? Isn't it? People will be very annoyed with me for talking to him like that, but he will give a hearty laugh actually. I know him. That is the merit of that person. And that's why he still remains big actually. Okay. Never mind, that's a bit of digression. Now the point I am trying to tell you is, because it is a techno-commercial document, and because many of your readers, important readers, are going to be from non-technical background, you must communicate the invention well for them. For that, you begin with the field of invention. Write about 2 or 3 paragraphs on that. What is it about? It's a diagnostic tool. Okay? Diagnosing what? What is the origin of diagnostic tools in that discipline? And what was the success? You know, just mentally prepare the guy to various things. Then, background of the invention. Here, why do you invent here? Why? Why? Somebody like Thomas Alva Edison invented because, hey, I don't know any other thing here. He always had that inquisitive mind. And people asked him, after he came back, Edmund Hillary, after he came back from Everest, hey, why the bloody hell did you climb there here? You know it is how difficult it is. He said, I wanted to climb because it is there. That's all. And New Zealand and the Austrians have a much better history of rock and snow mountain climbing. Okay. Remember, it is a New Zealand guy who could climb Everest first, along with the local guy. Okay. So the point I am trying to tell you here is background. Nowadays, invention occur because they want to solve a practical problem that they are facing. Why are drug companies investing more and more money on arthritis? Big gold mine. More companies are investing in cancer research, more money. Why people are interested in obesity? Money to be made. Plastic surgery, reconstructive surgery, cosmetic surgery, lots of it actually. So, background is, you want to solve a problem. Identify the problems. Summary of the invention. what do you propose to do? List of drawing. People will ask me whether drawings in a patent specification is mandatory. Unless it is a mechanical device, it is not mandatory. Okay. Because one page of drawing can save you 3 pages of description. So I say that even if it is in an organic chemistry, there must be a molecule. Keep that molecule diagram. Okay, it is easier, you know, the valency, bonds, bonding, everything. So drawings are always good. Put it actually. Detailed description, claims and abstract. So if you put all these 8, summary appears as part of the specification. Abstract is separate. And the summary abstract alone is shown for the purpose of searching. And very often what you do is an abstract is nothing but the first claim itself. You look up your, what you see as the first claim will always be the abstract actually. Maybe some cosmetic changes here and there actually. Okay, that much for you. This I think I have spoken about it. Form 26 is form of authorization. Form 5 is declaration of inventorship. Form 1 is application. All right. This is one important rule. And I think when I do it, I am done with that actually. When is your bus? 5 o'clock or 5:30? They must have informed you the bus timing. But it will wait for you, but at the same time, I don't want to, I know it's about 1 hour of journey for most of you actually. Never mind. I think he is coming to remind me. I am aware. It's right actually. You know, everybody has a job to do and that is his job actually. Okay. Hey, 10 minutes. I'll finish that. Tell the bus guy to hold on. It's important. Hey, this is one important thing. Local filing rule. If the invention originates in India, if most of the inventors are located in India, that the word used is resident in India. He may be a foreigner, he may come here in assignment, he discuss things for you, then he becomes a resident. If he comes on a, if he comes on a tourist visa, he is not a resident. He comes on a visa which is equivalent to H1 or a work permit and all that, he becomes a resident here. So the first application will have to be in India. If they fail to do it, the patent becomes invalid patent. Okay. And not only that, the applicant and inventors may also be open for a criminal prosecution which will make them go to jail in 6 months. Okay. America has got that rule. So the problem is I have seen some Indian patent, Indian company, foreigner, Indian applicant assigns the patent to him, he files it first there, and the same patent is granted there, and it comes back to India, and I tell them, please keep quiet. If you say that you applied for a patent outside without getting the permission of Government of India, without first making an Indian application, you are committing an offence under Section 39 of the Patent Act. So, foreign filing rule is very, very important. Examination about it. Request for examination within 48 months here. But I do it in 12 months actually. But luckily, my colleague has put in all the essential details there. Anyway, have a look at it. What happens is, you will be reading about this patent specification, patent cooperation treaty. In that you will have, normally what they do is, I make a complete specification here. Within 1 year of first filing, we will also file a patent cooperation treaty agreement. There we will ask for an international search report. That report comes within 18 months. And when it comes, we know for sure whether it will result in a patent or not. Okay, reasonable, intelligent, educated guess. Okay, if we do that, That is important, and publication, that's fine, I told you that. Examination, well, I think Matsudan is going to do that. They will look for novelty, utility, inventive steps, statutory subject matter, application formalities, issue of first examination report, and this is the fee, and this is the timeline, pre-grant opposition. I am not going to focus on it. Do you have a timetable of this lecture? Give it to me. I have a feeling Matsudan is going to, that you are going to see it tomorrow. Session 4, opposition to patent. I am skipping this. Okay. This also I am skipping. This also I am skipping. This also I am skipping, yeah. There have been some changes. Online filing mandatory. Special provisions for startups, which is very, very crucial. Okay, within 5 years, you can ask if your company is less than 5 years old, you can tell the patent office to examine it fast. Chalo, that's all about it. Expedited examination. That expedited examination is nothing but there is an international search report, and you tell the examiner, look here, somebody already has done it, so do it fast. It makes a lot of sense there actually. Reply, 6 months to 1 year. Within 1 year, you have to comply everything. Deletion of claim, refund of fee, amendment, everything. Amendment and all, there will be separate lectures on that. We will look at it, and I think I am done with that actually. Okay. Thank you all here.